Okay. I will call the meeting of the Legislative Audit Commission to order. It is December 22nd, and this meeting is a remote meeting held in conjunction to the rules that were adopted by the House and the Senate. I want to thank members and members of the public for their patience. We did delay this meeting several days to give time for members and the public to look at the postings of the actions we're going to take today. So members, over the last couple months, we've talked quite a bit about a legislative housekeeping bill, the budget for the Audit Commission, and also the single audit. So I think we're going to start right off, Mr. Nobles, where we're going to go through the housekeeping bill proposals. What I would like to do is take each item one at a time and that we vote on them. Because we are conducting the meeting remotely, that we will need to have a roll call for each item. I don't anticipate that all of them will pass or pass unanimously, but we have had time to look at them. So we take a motion and then have discussion on the item and then vote. So maybe Mr. Nobles, if you can give a quick summary of what we're going to be going through today.
Yes, thank you, Mr. Chairman and members of the Legislative Audit Commission. As the chairman said, we have proposed in a document that was sent to the commission on December the 16th, various amendments to the statute that governs the operation of the Office of the Legislative Auditor. That statute was originally enacted by the legislature in 1973, and it has been amended several times since then. So we propose amendments as we confront situations where there may be some ambiguity or some other reason for amending our law. So that's what you have before you, and I will go through them one by one, Mr. Chairman.
So is there a motion to consider proposed amendment number 1?
So moved.
Mr. Chairman and members, then amendment number 1, I consider to be a housekeeping provision, which simply puts in the law something that OLA has been doing since it was first created, and that is what we used to call investigations. In fact, those investigations were conducted even when it was the office of the auditor that was in the executive branch. And that was carried over into the statute that created the Office of the Legislative Auditor. We can now call those special reviews. I think that's just a better title. Sometimes a special review does focus on alleged misuse of public funds. We have found that misuse before, and we coordinate those kinds of special reviews, investigations with law enforcement, depending on whether it's local, or federal, state or federal. So this would simply say, again, recognizing what has been the case for many decades, that the legislative auditor may conduct a special review to fulfill a legal requirement. And sometimes there are provisions enacted into law that direct the legislative auditor to conduct a special review or an investigation. We could also conduct a special review to investigate allegations that an individual or organization subject to our audit has not complied with legal requirements concerning the use of public funds or other public resources. And again, we do receive a lot of allegations. People bring them to us, legislators sometimes do, the public, also whistleblowers from within government bring those allegations to us. And we consider ourselves responsible for considering them and following up on them if they fall within our jurisdiction and we think that they really require some immediate action. We sometimes roll them into financial audits or other kinds of reviews that we do. But again, it has been a part of our work for many years. And then we would also propose that we would do special reviews in response to legislative requests. And we get a lot of those. They're not always put into law. I mean, you have cautioned your colleagues not to put those requirements in law, but we still get requests. And sometimes we think that they are worthy of a special review. We would again consider them during your topic selection period, but sometimes they don't get through that process. They're not quite applicable to a financial audit, and so in terms of some legislative requests that we receive, we conduct a special review. And then we also have responsibility to look at conflicts of interest. The legislative auditor is notified by executive officials if there is a conflict of interest by an official or employee. And we have conducted a number of investigations or special reviews of conflicts of interest. So that, Mr. Chairman, is proposal 1.
And Senator Kiffmeyer, was that your motion?
Yes, it is, Mr. Chair.
Is there any discussion? Is there any discussion? Clerk would take the roll.
Senator Benson, Representative Bernardi,
Pass.
Representative Erickson,
Aye.
Senator Frentz,
Aye.
Representative Hansen,
Aye.
Senator Kiffmeyer,
Aye.
Senator Klein, Senator Curran,
Aye.
Representative Liebling,
Aye.
Representative Pearson,
Aye.
Representative Quam,
Aye.
Senator Rest.
Aye. I would like to come back to me, please, as well, Connie Bernardi.
Representative Bernardi,
Bernardi votes aye, and I apologize. I had a dog issue and I'm back. Thanks.
we had 10 yeses, 0 nos.
Motion is approved.
So
Proposed-
proceeding on with item number 2, Mr. Chairman, and it actually has several different pieces, although they're put together because they amend a subdivision. So the first one I think is fairly technical. We simply change the name of the 3 support staff that we have provided for in the law. They are currently called confidential secretaries. And that I think implies that they just work for each of us individually, the legislative auditor and the 2 deputies who are authorized to appoint them. They actually serve many, many functions within the office. They are, broadly speaking, administrative support specialists, and we think the statute ought to reflect that. Item C, we strike simply because it's no longer needed. There was a provision in the past that required us to do some oversight of transit and to appoint a fiscal oversight officer to conduct those responsibilities. The responsibilities were repealed, so we no longer need that officer to be required to be appointed by the legislative auditor. Item C really is, again, just technical. That makes it clear that the legislative auditor, the 2 deputies, and the support specialists, administrative support specialists serve in the unclassified service, and that all the other employees in OLA serve in the classified civil service. And again, that is the way it's been since the office was created in 1973. The final item in proposal 2 is more substantive. We had, I think, quite a bit of a discussion about this and some concerns expressed. And so I have narrowed what is being proposed here so that a provision that does apply to employees in the classified civil service would not apply to those employees in the classified service who serve in the office of the legislative auditor. And I think that that needs to be done because that provision would allow a classified employee in the office of the legislative auditor to take a leave of absence to run for a public office, even a partisan office. There's another provision that would say that I could not as legislative auditor, require a classified employee to take a leave of absence. So I think either of those are not really consistent with the fact that the Office of the Legislative Auditor is, very strictly speaking, a nonpartisan office. And we talked about this quite a bit before. And I again tried to narrow it to just say that a classified employee in the Office of the Legislative Auditor, actually no employee, either in the unclassified or classified service, can run for a public office. I just think it's incompatible with our status as a nonpartisan office. So I'd be happy to answer questions.
Members, is there a motion for item number 2?
Oh, Mr. Chair.
Representative Liebling.
So thanks, Mr. Chair. You know, the problem is we've got items here combined in 2, some of which are non-controversial or probably that I'd like to support. And frankly, I'm still bothered by the 4th piece, the D piece, and think that, and would like to have more discussion, but you know, probably don't intend to support that. So can we divide these and do the A, B, and C as one motion, and then and then have a separate motion on the D piece?
So Representative Liebling and members, there's no motion on the floor. So any motion that could be made, you could make that motion rather than having to divide a motion that's already been made. There is not a motion on the floor.
Well, thank you, Mr. Chair. Then I would move adoption of I think Mr. Nobles said the A, B, and C portions. It's hard. I'm switching between the document on my screen and looking at all of you in the meeting, so it's a little awkward. But I think that the piece about running for office is the piece I'd like to not include in there. So I think it's A, B, and C. Mr. Nobles, is that right?
It is actually B, and then a renumbered or lettered C, and then the old C is stricken, so that's why we renumbered. So it's a little bit confusing, but let's say B, C, and D. I think that will be clear. At least I understand what it is when I take it to the revisor.
Representative Quam.
I'll wait until we get the division and that done. I also had some concerns, but I think it's most appropriate we get that in order, and then we can debate probably the last part after we pass the non-controversial.
Representative Liebling, do you want to do just a close?
Restate the motion, maybe?
Yes.
Okay, well, I'm looking at the language now too, and it is confusing. So I'm going to move that we adopt, under the second proposed amendment, that we adopt what's in it's hard. It is hard to state this. In the proposed changes, A through D. Oh, I'm sorry, wait, no. Yeah. A through D. I think that captures it. Does Mr. Nobles, do you agree?
Mr. Nobles?
Mr. Chair and Representative Liebling, I think that's clear. There is actually no amendment to A, but let's just take what you proposed. I think that'll work.
Members, are there any questions on this motion? Any discussion?
Mr. Chair, I apologize for joining late. Was the concern over elected officials, over legislative audit staff running for office, was that addressed already in conversation?
Senator Benson, so the motion that was made did not include that section, so that we would take the non-controversial components above that first, and then if there is consideration for that, I would take a motion on that particular item. So
thank you, Mr. Chair, for the clarification.
Any further discussion? The clerk would take the roll on the Liebling motion.
Senator Benson,
Aye.
Representative Bernardi,
Aye.
Representative Erickson,
No.
Senator Frantz,
Aye.
Representative Hansen,
Aye.
Senator Kiffmeyer,
Aye.
Senator Klein, Senator Karan, Senator Karan,
I think you're muted.
Sorry, aye. Aye. Can
thank
hear
you.
me?
Yep. Representative Liebling,
Aye.
Representative Pearson,
Aye.
Representative Quam,
Aye.
and Senator Rest.
Aye. Aye.
Thank you. We have 10 yeses and 1 no.
The ayes have it, and the Liebling motion is adopted. Now we are on the item E on proposed amendment 2. Is there a motion to bring that before the commission?
I'll move that motion,
So-
Mr. Chair. This is Mary Kiffmeyer.
Senator Kiffmeyer moves. Item E on option number 2.
Mr. Chair, I can't find my paper copy. Could you please read what that is, please?
Mr. Nobles, could you read that?
Thank you.
Yes, Mr. Chairman, it is proposed that Minnesota Statute Section 43A 32, subdivision 2 and 3, not apply to employees of the legislative auditor. The 43A 32 subdivisions 2 and 3 involve classified employees being able to either take a leave or not be required to take a leave to run for public office. I understand why that is a provision in law for classified employees. I certainly know, and I think the chairman knows of former classified employees who have utilized or chosen not to utilize that provision to run for a public office for the legislature. Given that, as I've said a number of times, given the nature of, well, let me finish reading because then it makes it even more explicit. It says, first of all, that the leave provisions do not apply to classified employees in the Office of the Legislative Auditor. And then it states explicitly, an employee of the Legislative Auditor may not be a candidate for an elected public office. And so it makes it clear that by law, an employee at the Office of the Legislative Auditor can't run for a public office. That would include, a lot of different offices, some partisan, some not. But that's what I propose. And I will just remind you that I am proposing this because I did have an employee come to me and say he was running for a seat in the Minnesota Senate. And we immediately told him that we felt that that was incompatible with his working at OLA. And fortunately, he agreed. And so he voluntarily resigned his position here. I cannot count on other employees to do the same as long as these provisions of law exist. So I feel strongly, I've felt strongly for as long as I've been legislative auditor, that to uphold the status of this office as a nonpartisan office, that employees here should not run for a public office. So that's my proposal, and I'd be happy to take questions. I'd be also happy for the two deputies to offer their opinions if they would like to, because I think we have a common concern about an employee here running for a public office.
So I have Representative Liebling and then Representative Quam. Representative Liebling.
Thank you, Mr. Chair. I just have a question. This is kind of basic, and I suppose I should know this, but I don't. I always get confused about the meaning of the terms classified and unclassified employees, and that's pretty key here. So,
Yes.
Mr. Nobles, could you just be, and I'm sure the public watching too probably doesn't know this either, but please just make that explicit. Who are we talking
Sure.
about here?
Mr. Noble.
Mr. Chairman, Representative Liebling, members of the commission, the state has a civil service system which is divided into two parts. One, there are classified employees, and if you are a classified employee, you serve a period of time during which you can be dismissed for any reason. But after that preliminary time, it's typically a year, you essentially gain a tenure to your position, and you can only be removed for cause. An unclassified employee, typically, there are exceptions, I being one and the deputies, but typically an unclassified employee, many of them are appointees of the governor or governor's staff or other political offices appoint their staff to the unclassified service. And so they serve at the pleasure of the appointee and can be removed for any reason or no reason. So that is the basic distinction, whether one has tenure or not.
So, Mr. Chair, if I could just, thank you for that clarification. So, because a lot of people use the term civil service, and that kind of is a more, and I know in Minnesota we say classified. Okay.
Yeah.
So what you're talking about here are, so as I'm understanding it, the unclassified employees already can't run for elective office under our current law if they work in the OLA. Is that what I'm understanding? And it's only now that the change you're asking for is really the classified or the civil service employees. Is that correct?
Mr. Nobles.
Well, there is not an explicit provision which says that the unclassified employees in the Office of Legislative Auditor cannot run for a public office. The only provision that I recall, and I don't have it exactly in front of me, but there is a provision that says the legislative auditor, while serving as legislative auditor, cannot hold any other office. So I would certainly be prevented. But what I'm proposing is that all of us, both classified and unclassified employees in the Office of the Legislative Auditor, not be allowed to run for public office as long as they are employees of the office.
Okay, so thank you for that clarification. So let me just quickly say that I don't support the change. And the reason I don't support it, well, I understand the concern that Mr. Nobles has. First of all, we're balancing this concern against an extremely important right that people have, which is to run for office. And this could be partisan or nonpartisan office. Clearly, the Constitution might have some, you're not supposed to serve in different branches of government, so that would prevail if people would win. But I also think that the concern here might be a bit overblown, because while everyone understands that the office of the legislative auditor needs to be nonpartisan and needs to be out of that fray as much as possible, individual employees who might serve in lower level non-decision-making positions, I don't think that the fact that somebody might be serving in some elective office somewhere is necessarily casts a bad light on the office. I mean, I could see a situation where it may, certainly if one of the higher, decision-making employees was viewed as partisan, that could be a problem. But I think this is just too broad, and that's what concerns me, because the interest of the employees in being able to have their right to run for office is so great. So I just think this doesn't set the right balance between those things. I'm really interested in hearing other people's thoughts, however.
Representative Quam.
Thank you, Mr. Chair. And I think there's a few places where there's a definition of partisan office. School board, city council, there are a lot of small town type offices that aren't partisan. And I could see if this could not run for a partisan office or some definition there. The problem I see, it's justifiable to be concerned a judge, a legislator, and others would not partake of an activity that there'd be a conflict of interest. I think even certain members of the medical profession are not to perform certain procedures on family members. So I could see if there was a preclusion of preventing someone from doing a conflict of interest. You know, if you own a large percentage of stock in an entity that's being audited, I see that as being a conflict. It gets very gray and muddy. I understand and agree that the current situation is problematic. I would hope that there could be a less draconian that would allow to run for nonpartisan and add in some language in regards to conflict of interest. Because if you are involved on a school board and you're auditing the Department of Education, you know, that type of thing. So I would like this component to have more detail and be fleshed out, and also be restricted slightly from a global, because you know, there's a township board where you happen to live in the township, and I don't see you'd have any conflict for the most part serving. So now that the dogs have noticed somebody there and I've spoke my piece, I will go silent.
Mr. Chairman, may I respond to some of the points that have been made?
Jim, I'd like to, because we've
Sure.
got two more, I just want to roll through them because I think.
All right.
So actually, we've got three more. So Senator Rest, then Representative Erickson, and then Senator Benson.
Thank you, Mr. Chairman. Well, I strongly support this provision. I believe that we all take on types of restrictions on our activities when we run for office, and I believe that the independence of the OLA's office is paramount, and is our first responsibility to ensure that it remains so, and to have and also to have the office function effectively. Representative Quam just mentioned, well, what if you're a school board member and you're on the OLA's program evaluation staff? Well, right from the beginning, you may not be involved in any program evaluation that involves the Department of Education, Education Minnesota, the School Boards Association, the administrators, because it's a conflict of interest. Prima facie, it's a conflict of interest for you to be involved in any of that. And so for that particular evaluation, and we know that we evaluate education issues in the K through 12 or E through 12 system almost every year. So that, in my mind, that employee becomes absolutely irrelevant and useless, and otherwise they might have had something valuable to contribute. But the fact of the matter is they're tainted, and their judgments cannot be trusted. I think this just makes it clear. We know that members of our staffs, our own staffs, our LAs, they're not classified. We can all fire them today, or at least in the Senate. individual members have the authority to fire their LAs at will. They could all be gone by this afternoon. Maybe in the House, that's not according to your rules, but it certainly is in the Senate. On the other hand, a lot of times we encourage our LAs to run for office, to run for local office, or even a partisan office to run for the legislature. And particularly if they're not running against us. But I think that the OLAs, but we don't demand or even pretend to think that our staff is not partisan. I mean, I can't imagine what the Senate would think if, for example, Mr. Boddern, the chief Senate counsel, decided to run for county commissioner. And yet he oversees all of the staff that gives us advice on legislation that deals with county government. It's just inappropriate on its face in my mind. And I don't think that it happens often, but I think if the policy is there, that it makes it clear as a condition of employment that someone knows going in that they would not be able to stay in the OLA's office if they wanted a career in politics of any kind. So, of course, it's a right to run for office and to vote. We don't tell them they can't vote, but I don't think that this is any kind of punishment or withholding of their rights as citizens to require this as a condition of employment. We do it all the time, and it still is constitutional, and it's not denying anybody their right to participate in public life. So I hope that we will adopt this policy. Thank you.
Senator Erickson, and then Representative Erickson, and then Senator Benson.
Thank you, Mr. Chair. I agree with Senator Rest. I have seen examples of conflict of interest occur, not of course in the Office of Legislative Auditor, but in our agencies, in that there are employees who run for like township board. I have one in my township, and there's a definite conflict of interest there that I have realized, in that the knowledge brought from that agency to the township board has skewed the ability to see the issues clearly. And so I support Senator Rest on this for the simple fact that conflict of interest does occur.
Senator Benson.
Thank you, Mr. Chair. And I remember when we were having the discussion about the partisan presidential primary, and Mr. Nobles raised that if we start having partisan primaries, that his staff wouldn't be able to vote, because then with the list being public, everyone would know their political position or have an indication of their political position. This is how seriously the legislative auditor takes their non-political status, and so I'll be supporting this provision.
Senator Kiffmeyer.
Thank you, Mr. Chair. And I support the motion in its entirety as well. I think one of the things you become aware of is that everyone in the auditor's office, every single one, is all involved in audits. So it's not like it's just here. These are very highly skilled, very knowledgeable employees, and every one of them, the work that they do is involved in an audit to one fashion or another. And they should be free of conflicts so that we can trust the results, so that the general public can trust the results and not run into this kind of a situation. And so I think that should be free at all levels, not just at one. And whether it's a partisan office or a nonpartisan office is really irrelevant. It's the conflict of interest that is the most crucial here. The other thing is for Mr. Nobles to be able to use all of his employees fully. If he has to deal with one, I mean, it could even be more, that are limited in this conflict situation that really restricts the work and the leadership of the Office of the Legislative Auditor. And the third thing is that I think it should be clear up front. Every employee, we owe it to them. Make this clear in the statute, so when they take the job, take the work, whatever they're doing, Mr. Nobles doesn't have to spend valuable, precious time explaining, dealing with this and going through it all. So I think those things, everyone in the office should be free of conflicts, best use of all employees, and then it should be clear up front, and I support the newly written E. Thank you.
I see 3 hands up, but I think each of those have already spoke. Are there any other members who have any discussion?
Senator Frantz.
Mr. Chair.
Oh, I don't have the whole, okay. I've got Senator Cran and then Senator Friends. Is your little blue hand up?
It sure is.
Okay. So
thank you.
Cran first and then Friends.
Thank you, Mr. Chair. And I support the proposal as well in its entirety as it's written. I think I've been with multiple employers that have that very same restriction, and knowing that going in doesn't deprive me of a right. The decisions I may make for my employment have consequences or may provide limitations. And as long as people know that up front, I think it's absolutely important that this amendment does help preserve the institution of this body. The nonpartisanship and the level in which it operates today throughout the entire organization is something we should cherish and that we have to fight hard to preserve. And I think this is one of those efforts that removes just conflict before it happens and make sure that we continue to maintain and the great work that's been done today. So I support it. Thank you.
Senator Friends.
Thank you, Mr. Chair, and thank you, Mr. Nobles. Thanks, members, for the discussion. I'm inclined to support it. I don't think it's quite as simple to say that the only concerns we have about partisanship are for those people that are running for office. Obviously, in many ways, when we seek impartiality, we know we're dealing with human beings that do have partisan leanings. And while I think they successfully squelch them most of the time, I'd just like to point out that this particular treatment suggests that if you're running for office, we're worried about you being partisan, and that's not okay. But if you're not running for office, everything's fine, and we just don't have to worry. I thought Mr. Noble's discussion of bumper stickers last time made a good point, which is a lot of people are partisan that don't run for office. Again, I'm inclined to support this. I just want to put out there, once we go down this road, it raises some questions about what future decisions we would make in the name of impartiality for the OLA. What things would we require of staff or ask of staff? What things would we seek for members of this commission? And thank you, Mr. Chair. I think that's my piece for now.
Are there any other members who wish to discuss? I am inclined to oppose the motion as it is written. I do think there is a difference between classified and unclassified employees. I think we have precedent throughout, a long precedent with the Hatch Act at the federal level in terms of partisan versus nonpartisan. If we look at division of responsibilities in terms of oversight, the state auditor looks over local government and we look over state government. And so I think township officers, soil and water supervisor, school board, city council, and county commissioner are different than partisan office. But the motion is broad, and so as it is written, I will vote against it. Senator Kiffmeyer.
Sorry, Mr. Chair, I forgot to take my hand down.
Okay. Any other discussion?
Senator Rest has.
Senator Rest.
Thank you, Mr. Chairman. Ordinarily, I would agree with you that that offices where on the ballot, there's no party designation. That's the issue, party designation. But I can tell you that the county commissioners in Hennepin County run as Democrats or Republicans. And I believe that that's true in almost every metro county. They are endorsed by their party. And I believe that even though they do not have party designation, that they certainly are partisan. And they're identified as such. And as a matter of fact, they're proud of it. If they can win, the endorsement of their party. So the notion that it's a state auditor that will have some sort of fiduciary responsibility for accountability of county government, I don't think goes very far in this instance. And I wonder, is there a motion on the floor, Mr. Chairman?
Yes, there is a motion to approve, so, and as written.
And who made the motion? I'm just curious.
Senator Kiffmeyer.
Okay, thank you. Just, I didn't hear that to start with. Thank you very much.
And we've got Representative Liebling.
Just quickly, Mr. Chair, I just want to correct that. In Olmsted County, which is, you know, pretty large county, our county commissioners run nonpartisan and they protect their nonpartisanship. So I just want to make that very clear.
That's not true in the metro.
Senator Benson.
And thank you, Chair Hansen. I think the larger point that Senator Rest made is that Mr. Nobles has jurisdiction. If we decided that there would be a review of, you know, cities under 5,000 and their allocation of transportation funds and the results of that, that would be under his purview if the legislature decided to give him that instruction. And so even though that city council might not be partisan, if a member of his staff is sitting on that city council, they would have to recuse themselves. And so as much as I understand the part, you know, letting people serve in nonpartisan offices, I think with the breadth of this jurisdiction, it makes things a little different.
Mr. Nobles, I said I would give you the final word after all the discussion. I think this is a good discussion. So, Mr.
It is, Mr. Chairman and members, thank you. I appreciate the discussion. I appreciate the different points of view. I really won't add anything that hasn't already been said. So I think we'll leave it to the vote of the members.
Is there any further discussion? Any discussion? Clerk will take the roll.
Representative Hansen,
No.
Senator Coran,
Yes.
Senator Benson,
Aye.
Representative Bernardi,
No.
Representative Erickson,
Aye.
Senator Friends,
Aye.
Senator Kiffmeyer,
Aye.
Senator Klein, Representative Liebling,
No,
Representative Pearson, Representative Pearson, is he still with us?
He's online.
Representative Pearson,
Maybe proceed and come back to him.
okay, Representative Quam,
Aye.
Senator Rest,
Aye.
Representative Pearson, not sure what happened. He's still showing online. I'm not sure. Do we wait or how do we proceed with this?
We should proceed.
Okay,
You called them thrice, so.
okay, we have 7 yeses, 3 nos, 1 absent, or 2 absent if you count Pearson.
Motion is adopted.
Correct.
Meyer motion is adopted. Proposed amendment number 3.
Yes, Mr. Chairman, thank you. And I believe this one will be a little less controversial because we're really just kind of cleaning up some very antiquated language. This is language, again, that was carried over from previous statutes into the 1973 law that created the office. We don't do audits quite like this anymore. We follow generally accepted auditing standards and set the scope depending on the objectives of each audit. But it really does still have an important place in what we've retained, and that is to be very explicit about the jurisdiction of the Legislative Auditor's Office and the responsibilities to audit all of the organizations in the executive branch and in the judicial branch, various boards and commissions and other organizations that are created by the state or receive funds from the state. This is not an expansion of existing authority. It's simply a housekeeping cleanup of antiquated language.
Representative Erickson moves adoption.
Representative Erickson moves adoption. Is there any discussion? Is there any discussion? Clerk will take the roll.
Representative Hansen,
Aye.
Senator Curran,
Aye.
Senator Benson,
Aye.
Representative Bernardi,
Aye.
Representative Erickson,
Aye.
Senator Frentz,
Aye.
Senator Kiffmeyer,
Aye.
Senator Klein, Representative Liebling,
Aye.
Representative Pearson,
Aye.
Representative Quam,
Aye.
and Senator Rest.
Aye.
11 yeses, 1 absent.
The Erickson motion passes. Proposed amendment number 4, Mr. Nobles.
I'm sorry, I was muted. Number 4, again, I think is housekeeping. This retains existing language which directs the legislative auditor to give priority to audits at the Department of Human Services. But it takes away some of the very prescriptive language that was adopted some years ago. It does include new language, which I think Senator Curran has championed in the past. And if he wants, he can certainly speak to that. And that simply directs that we not just look at the expenditures at the Department of Human Services, but that we potentially, in some audits, we will track the expenditures throughout the human service delivery system. So that's the proposal of number 4, Mr. Chairman.
Senator Curran.
I'll make the motion to approve this proposal.
Senator Curran moves proposed amendment number 4. Is there any discussion? Senator Curran.
Mr. Chair, Mr. Nobles spoke on some of the comments of what I've been working on. I do think one of the key things that this legislative body needs is when we go out and do these reviews, and I think I've spoken specifically in the Department of Human Services, when we're looking at services, we need to look at what the impact is, not only within the Department of Human Services state level, Department of Human Services at the county level, but also the actual provider. And so we need, and I think we'll have more of this conversation as we talk about the single audit, but the intent would be is to make sure that we get the entire value proposition understanding of that life cycle of the transaction. I think the OLA's office is the only one that can give us that, the eyes and ears and the insight to allow us to properly understand the value we're getting, not only from a financial and a compliance perspective from statute, but also the value proposition of our rules and regulations and how they apply to the utilization of the resources that actually touch the people we're intended to serve. Thank you.
Is there any other discussion? Any other discussion on the Cran motion? Clerk will take the roll.
Representative Hansen,
Aye.
Senator Curran,
Aye.
Senator Benson,
Aye.
Representative Bernardi,
Aye.
Representative Erickson,
Aye.
Senator Frentz,
Aye.
Senator Kiffmeyer,
Aye.
Senator Klein is absent, Representative Liebling,
Aye.
Representative Pearson,
Aye.
Representative Quam,
Aye.
and Senator Rest.
Aye.
11 yeses, 1 absent.
The ayes have it, and the Cran motion is adopted. Mr. Noble's proposed amendment number 5.
Mr. Chairman and members, proposed amendment number 5 addresses probably one of the most important subdivisions in our law, and that is the requirement that public officials, other organizations and individuals that receive public funds cooperate with the Legislative Auditor's Office and provide us with all of the data, the documents that we need to conduct an audit, an investigation, special review, or an evaluation. I have proposed this because we did have the experience during one audit that the entity, organization that we were auditing said the law only provides you with data that you may need for the audit, and we don't think you need it. And so we spent a considerable amount of time with that organization and their legal counsel on this provision. And I would like to not do that again. I would like it to be clear that the decision as to what data and documents and other material we need for an audit is decided by the legislative auditor, not the organization that we are auditing. And it just then cleans up a little bit of language that is kind of awkward and requires organizations to cooperate with the legislative auditor.
Is there a motion to approve amendment number 5, proposal number 5, excuse me?
Representative Erickson moves adoption.
Representative Erickson moves adoption of proposed proposal number 5. Is there any discussion? Is there any discussion? Clerk will take the roll.
Representative Hansen,
Aye.
Senator Curran,
Aye.
Senator Benson,
Aye.
Representative Bernardi,
Aye.
Representative Erickson,
Aye.
Senator Frentz,
Aye.
Senator Kiffmeyer,
Aye.
Senator Klein, Representative Liebling,
Aye.
Representative Pearson,
Aye.
Representative Quam,
Aye.
Senator Rest.
Aye.
11 yeses, 1 absent.
The ayes have it, and the motion is approved. So the Representative Erickson motion is approved. Proposal number 6, Mr. Nobles.
Mr. Chairman, and with respect to the time we have, I'd like, and because they are closely related, I'd like to take number 6 and 7 together. They relate to the same issue. And if you've looked at this, you might have asked yourself, where did Mr. Nobles get the audacity to propose these two changes in the law? In essence, what I'm proposing is that the Legislative Audit Commission cannot obtain access to not public data that we have in our work papers. You have never used this provision, which allows the commission to obtain access to not public data that we have in our work papers by a resolution. The only exclusion is that you could not get access to tax data that we have. The reason I'm proposing this is that we very often are dealing with people that are providing us with very sensitive information. And they have to, by the amendment that, and by the legislation that you just saw in the previous amendment, they have to provide that to us. And then we also go to people who have information, but are very wary of giving it to us, giving us whistleblower information or being interviewed about a very sensitive topic. And so we have the authority, and we do quite frequently offer to protect their identity if they will provide that information to us. And so we give them that assurance, that absolute assurance that we will, according to the law, protect all not public data and documents from unlawful disclosure. Now, they could then look at the existing law and say, well, but Mr. Nobles, your Legislative Audit Commission could find out who the whistleblower was if they pass a resolution, or they could look at maybe some of the health records that you obtained when you did an audit or an evaluation if they pass a resolution. So we're not so sure that you can absolutely assure us of the confidentiality and the protection of these data. So that's why I'm proposing to eliminate that possibility. Again, it is not an authority that you've ever used, but it does hang over us because it's there in the law.
Representative Liebling.
Thank you, Mr. Chair. I have a question for Mr. Nobles. Under the current law, if commission members get a hold of some of this non-public data and reveal it, is there a penalty for us? I mean, the law doesn't allow us to just, once you give it to us, it's certainly restricted by law, right?
Mr. Chairman. Representative Liebling, that's correct. The law clearly says that if you obtain not public data, even though you're not, as legislators, subject to the Government Data Practices Act, otherwise, this law that we're talking about here does say the penalties of the Government Data Practices Act would apply to you. Another complication, of course, is that I'm not sure how you as a commission really have an informed discussion about not public data, because you do not have any authority to hold executive sessions that I'm aware of related to this. There may be some other situations with the ethics committees and other places, but I also just think this is difficult to comprehend how this informs you as a commission if you only are allowed to deal with this as individuals. But you're right, Representative Liebling. If you were to disclose not public data that you got from the Legislative Auditor's Office, you would be subject to the liabilities, both criminal and civil, of the Government Data Practices Act.
Well, thank you for that, Mr. Nobles, Mr. Chair, if I may.
Yes, Representative Liebling.
Thank you. And so, that being the case, I think the solution being proposed here is the wrong one. I think we should have the ability to have an executive session if we need to discuss non-public data. And frankly, the last provision that we just passed about requiring people, this ties together, the requiring people to cooperate, which I fully support and supported, with the legislative auditor. If there's ever an allegation that this has been misused in some way, what is the recourse that anyone might have? I assume it would be to us, the commission, right? And so if we then don't have the ability to look at all of the facts, I think so in a way, I think these two things go together. I actually have in the past been concerned that we as legislators don't have a mechanism to get non-public data and be required to keep it non-public. You know, right now, other than this very narrow exception for the commission, if we as legislators, you know, get somebody's financial data, now it's public, right? That should not be the case. So I think we're going the wrong direction here, frankly. I understand your concern, but I think you should be able, especially since we've never even used this, I think you should be able to say to anyone who's concerned that we would be under penalty of law. We would be subject to penalties if we revealed it, just as you would. So this is something that I don't support. Thank you.
There is not a motion on the floor.
Mr. Chairman, I would just like to respond by, I really respect that point of view, and I think you make a good point, Representative Liebling, that this is a mechanism that you could use if you ever had cause to have concern about some work we did, what data we had. This is an avenue by which you can obtain it. So I anticipated that there would probably be some questions and concern about eliminating this possibility for commission members, but I've stated my reasons, and so I will leave it to you as a commission to vote on that. And if you are not comfortable with this, Mr. Chairman and Representative Liebling, commission members, I have always wanted the legislature, the Legislative Audit Commission, and other committees to craft a way of obtaining not public data through executive sessions. I know it's done in Congress. I know it's done in some other legislatures, but there have often been occasions when we have information about issues that we would like to disclose to you in an executive session, but we cannot because you don't hold executive sessions.
Senator Benson.
Thank you, Mr. Chair. And it has been a while since I served on the Capitol Security Commission, but when that was created, it gave us the ability to go into an executive session, I guess it would be, to review information that we needed for our work but wasn't available to the public. And then there's a specific time frame. The meetings are recorded. There's a specific time frame when they're released, et cetera. And so yes, we should do something about giving us access to non-public data, but it has to be within a restricted, in a more restricted environment than the public sessions that we're having now. I understand, Mr. Nobles, why you're bringing this language forward, but I agree with Representative Liebling. I think the better mark would be to create a closed session where this information could be reviewed. And so I know you were trying to get this ready for next session, but I'm hopeful perhaps we could have a review of something about the LAC being able to give notice, limited agenda, closed session for the purposes of reviewing information that is non-public. And as to the entire legislature having this authority, maybe if we start here and it's effective and well vetted, we could expand it to, for example, judiciary committees and things like that. But for now, I'm going to post the language as presented and ask for a proposal about a closed session.
Senator Rest, and a reminder, we do not have a motion on the floor.
I understand that, Mr. Chairman. I agree with Senator Benson. I think that we need a little bit more time to think this through. And I, for one, if any of us are going to have access to that, to non-public information under any circumstances, I want a pledge of that on penalty of being brought up on an ethics violation in our respective chambers if it is found out that we revealed that information. So it's not just us diving into information that people have a right to expect to be non-public, but that we have an obligation about it and to it, and maybe we need a little bit more discussion on it. And I just recall that it used to be the case, and in case you think that the people on the Legislative Audit Commission are not prone to reveal things, it used to be the case that we would get a paper copy and a of the program evaluation documents a day ahead of the legislature. They were confidential, and yet before the report was released, it was a headline in the paper, and the report was revealed through it could only have been through a member of the Legislative Audit Commission. And after that, we decided, nope, the Legislative Audit Commission is not reliable. They're not responsible. And I'm saying all of us as a group, they leak. They love to leak. And so the reports were not available to any of us except in an informal, non-official briefing prior to them being publicly released. And so we don't have a very good record of keeping confidentiality in a legal setting. And if we're going to go that route and think that we have the right to go that route, seems to me that there need to be consequences for leaking those that information. And Senator Benson, I think I was on the Capitol Security group the same time you were, and I think they did a remarkable job of, because the stakes were high. The stakes were very high about keeping the information that we would receive from the head of Capitol Security itself, and the law enforcement folks and so forth. We did a good job on that, but the Legislative Audit Commission historically has not been particularly reliable in that fashion. So if we have the occasion to do that, and we want to put that in, I mean, it's in the statute, I suppose, but I hope that we would understand that if there was a leak of that non-public information, that it from a whistleblower or whoever, that there would be consequences that none of us would like as members of the legislature, that would be a reflection on our character. So I'm making a pretty strong statement here, but it's based on the history of this group and the kinds of controversies we have found ourselves in over the last 30 years. And Representative Erickson has been a member of this commission, as well as Representative Hansen, any number of years, a couple of decades, I think, on and off, and Kiffmeyer as well. And they know this to be who we are. And I just, if we want access to non-public information, then we need to be trusted with it. And we do not have a very good record in that regard. And I don't think we should vote on anything today.
Senator Kiffmeyer, with a reminder that we don't have a motion on the floor.
Thank you, Mr. Chair. So two things that I think we are not ready for any vote or a motion on this 6 and 7 as written here today, considering our discussion. My question, Mr. Chair, is would it be appropriate, or Mr. Nobles accepted the task to go ahead and see if you could put some of these comments into some language for executive session and some of the other comments that were made today, if Mr. Nobles could do that. And my second thing, Mr. Chair Hansen, is that Senator Rest, the commission as a whole should not be castigated. It wasn't as a whole that they acted. It was individual members. And I think those who did not shouldn't be castigated by a definition of the commission as a whole, as if they did it. So I think what you were referring to was some individuals.
Chairman, point well taken. My apologies. But when we changed the way in which we had presented the reports, it applied to all of us, not just people who were not guilty of spilling the beans, if you will. But you're quite right. It's not a. It was the irresponsibility of individual members and not the commission as a whole. And I apologize for that.
That's okay. No apology needed. I just wanted to clarify, because I think your the point is there. But I don't
think it was ever used.
Yes. Well, I think the fact that it applied to everybody, it did so before as well. But I think not releasing it until the day of is perfectly fine. And I think those who complied before had no change, and those who couldn't handle it were having to be more disciplined in that regard. But Mr. Nobles, if you could respond to whether you think you might be able to put some language together for executive session,
Mr.
considering
Noble.
our.
Yes, Senator Kiffmeyer, Mr. Chair, members, I will do that, and then I will circulate it to the members. I think that language could actually be inserted right here into these two subdivisions, or one of them at least, about requiring an executive session if there is going to be a commission meeting to discuss the not public data. So I will do that.
And consequences, as Senator Rest suggested.
Yes, Mr. Chair and Senator Kiffmeyer, there are now consequences, but I think Senator Rest was also proposing additional language, and I will certainly work on that as well.
Members, we will be meeting in January. This is a timely time to encourage your leadership to make appointments or reappointments quickly so that we can begin business in January and start working and considering some of these items. We are now on item number 8. No action was taken on proposals 6 and 7, and Mr. Nobles is going to come back with some suggestions. So Mr. Nobles, number 8.
Number 8, again, is, I think, just a housekeeping provision. We struck out the language about special best practice reviews because we no longer do those. Some of you who were with the commission quite some time ago know that that was something that we used to do, best practices of local government. That was given over to the state auditor, which I think was appropriate. Also, just a small change that may seem pretty insignificant, and that is on the kinds of data that would reveal the identity of a whistleblower, basically. The current law refers to that it's data on individuals. There are data that are not on individuals that can, in fact, reveal the identity of an individual. And I know that that sounds pretty complicated, but data on an individual names the individual, but there are circumstances in which we have data that you could determine the identity of an individual. And we absolutely need to be able to protect that identity. And so that's a pretty technical amendment that is being proposed, Mr. Chairman.
Is there a motion to approve proposal number 8?
Mr. Chair, Representative Erickson moves approval of amendment number 8.
Erickson moves approval of amendment number 8. Is there any discussion? Is there any discussion? Clerk would take the roll.
Representative Hansen,
Aye.
Senator Curran,
Aye.
Senator Benson, Senator Benson,
Aye.
thank you. Representative Bernardi,
Aye.
Representative Erickson,
Aye.
Senator Frentz,
Aye.
Senator Kiffmeyer,
Aye.
Senator Klein,
Aye.
Representative Liebling,
Aye.
Representative Pearson,
Aye.
Representative Quam,
Oi!
and Senator Rest.
Aye.
All are yes. 12 yes.
The Erickson motion for proposal number 8 is approved. Proposal number 9.
Mr. Chairman, if you don't mind, I'd like to move to 10 and then come back to number 9 because it relates to the single audit, which is a separate item for discussion. And number 10 is really, again, just housekeeping. We're repealing provisions that I don't think need to be there. For example, mandates that we do audits of the Department of Transportation, Department of Public Safety. We're going to be doing those. We don't have to have a mandate to do them. There's also a repeal of a provision that was enacted some time ago that required the legislative auditor to look at the processes by which the Department of Public Safety sells driver's license records We were supposed to receive some money to do those audits, but Governor Dayton vetoed the provision that would have funded them. We can still do them. We still have the authority. Again, there just doesn't need to be a special provision in law directing us to do that work. Also, fairly recently, the legislature enacted a requirement that we do surveys of the compensation benefits provided to law enforcement. We are going to fulfill that with a report in the coming several weeks during the early part of the session. But the law actually requires us to continue to do them. And we don't think that that's a proper role for the legislative auditor. We certainly fulfill the responsibility the one time, but I just don't think this is an appropriate role to mandate for the legislative auditor to do on an ongoing basis. This really has to do with negotiations with the state patrol, and I think that those kinds of surveys ought to be a part of the negotiation process.
Is there a motion to approve proposal number 10?
Representative Erickson will move approval.
Representative Erickson moves. Is there any discussion? Is there any discussion? Clerk will take the roll.
Representative Hansen,
Aye.
Senator Curran,
Aye.
Senator Benson,
Aye.
Representative Bernardi,
Aye.
Representative Erickson,
Aye.
Senator Frentz,
Aye.
Senator Kiffmeyer,
Aye.
Senator Klein,
Aye.
Representative Liebling,
Aye.
Representative Pearson,
Aye.
Representative Quam,
Aye.
and Senator Rest.
Aye.
12 yes.
Ayes have it. The Erickson motion is approved. Mr. Nobles.
So, Mr. Chairman and members, back to proposal number 9, and that is one that has had a good deal of discussion previously, and that is to require the Commissioner of Management and Budget to be responsible for fulfilling the federal requirement to have an annual audit of the state's use of federal funds. We just don't think that our work in that area has been able to yield the most useful kinds of information for the legislature. We will still have authority and will still, in fact, audit the state's use of federal funds. That just is never going to go away, but we would rather do it under the scope and the kinds of methodologies that we think will yield better information than those requirements dictated by the federal government. So we have worked with MMB on this language. I certainly don't want to speak for them, but we showed them the previous language. They made some suggestions. I think we're in agreement with this language. Possibly Deputy Legislative Auditor Lyson, who has dealt directly with MMB on this question, would like to say a word or two.
Ms. Lyson.
Thank you, Mr. Chair. Yes, I did have discussions with MMB, and they did see the language that we proposed, and they did make some revisions and don't have any concerns over their responsibility for overseeing the single audit if that is what is decided. So I have nothing further to add. Thank you.
Thank you, Deputy Lyson. Senator Kiffmeyer.
Thank you, Mr. Chair. Mr. Nobles or Ms. Lyson, could you clarify, it says the commissioner shall contract with a qualified auditor. What would that mean, or give me some examples?
Mr. Nobles, Ms. Lyson.
Mr. Chairman, that would be an auditor, an audit firm, or it could be the state auditor who qualifies under federal requirements to conduct a single audit. There are many firms that do conduct single audits for local units of government. but the state auditor would also be qualified to do that. One of the requirements is that you have to have a peer review periodically. If you are the auditor of federal funds, the state auditor has that. We have that. We left it really, I guess, up to the commissioner to decide, rather than specifying in law that it would be either a firm or the state auditor. So that's the clarification I can provide to you.
Senator Kiffmeyer.
Thank you, Mr. Chairman. I appreciate the general concept here of not having the OLA do this and do support that. I think my concern is with an elected position. The state auditor is elected. It is a partisan office. And in doing this audit, they would be dealing with other members of the executive branch who would be receiving these kinds of funds. And so that's the root of my concern. And I, again, with the conflicts of interest and other issues, it seems as though it would be better to go outside that level to address that concern. But I'd be glad to hear other discussion on this matter.
Representative Liebling.
Thank you, Mr. Chair. And, I do support the idea, of course, of, I shouldn't say of course, but of relieving the OLA of the single audit responsibility. What gives me pause, though, about this language, maybe it's a little bit different than Senator Kiffmeyer's concern, but what appears to be sort of an open appropriation in the language to hire an auditor. If we had language saying the legislative auditor shall no longer bear this responsibility and the MMB has to figure this out, I would be supportive of that. For me, this language goes a little too far. Now, I realize that we're not enacting it. This is just going to the legislature for consideration, but I'm just a bit uncomfortable going beyond what I see of the scope of this committee's recommendation. I don't serve on the committees that would be making decisions about the budget for this or which auditor it should be or anything like that. So I'm a little uncomfortable approving the language in this form, although I do support the underlying concept. I just wish this could be a bit more narrowed to the scope where this commission is saying, we believe this should not be the OLA's responsibility. We believe it should be MMB's responsibility.
Senator Cran.
Thank you, Mr. Chair. And I share some of the same concerns from the open-endedness of the, as it's written today. Just so I think everybody understands this proposal, our goal is to get the single audit off of the OLA's consumption of their highly valuable staff and put them on more valuable activities that we fully depend on to do our job well. I would prefer to have, and I don't think the language where I want it to be either. I prefer to have the MMB contract for the services with integration or oversight of the OLA and for its implementation. I think you already have a portion of the financial oversight. And so I'd rather see a procedural proposal that makes sure that the integration or the oversight is identified from the OLA and how we conduct this, and that MMB contracts with a qualified public-private accounting firm. Thank you.
Mr. Chairman.
Mr. Nobles.
Actually, there is, I just want to remind you, there is no law that requires us to do the single audit. So it was a possibility, and I think we even discussed this, Representative Liebling, I think, raised this issue, that I could have simply told the commissioner of MMB that we're no longer doing it. And then he would have to, or she would have to figure out how to get it done. We could revert to that, although I think it is better to have, certainly this discussion and maybe some language as being proposed that this is not our responsibility, although frankly, I don't think there's anything in our existing governing statute that says we don't do something. So I can work on some language. The language that is here with the open appropriation, Representative Liebling, is what MMB wanted. And so it's incorporated here because I think there was an admonition from the commission that we work with MMB to reach some agreement between MMB and OLA, and then that the commission could agree to. This is it. So yes, they want an open appropriation from the general fund. But again, we don't need language on this issue. So I can certainly work on something that maybe takes a more narrow approach, bring that back up in our January meeting. So that's the current situation.
Senator Benson.
Thank you, Mr. Chair. And Senator Cran, I'm less concerned about the OLA having oversight on a single audit because it's not it is a kind of financial audit, but it is federal compliance, and any firm that meets the federal standard should be able to meet that compliance. I just don't want to keep putting things back on Mr. Noble's plate that can be professionally handled somewhere else, much for the same reason that they should be doing things that others can't do because of their unique role. I am uncomfortable with the open appropriation. I don't want it to seem to the legislature that we are recommending a good level of spending. And so I am not overly concerned about having pre-agreed upon MMB language leaving this committee. They will have their chance during the legislative process. And so those would be my two comments about this language. If we were going to a vote right now, I would move it forward simply because I think it's a good idea, but I think we can have a better shot if we take another review.
Representative Liebling.
Thank you, Mr. Chair. So since there's no motion on the table on this language, I guess I would propose a motion that Mr. Nobles be instructed to tell MMB that or let me take that back and start over. The motion would be that for the commission to resolve that we no longer are going to direct Mr. Nobles to do the single audit, and that he notify MMB of our action so that they can take appropriate action now going into the new legislative session. Maybe someone could help me with that a little bit because I'm just putting it together on the fly here.
Mr. Chair, I think this is too important to do on the fly. Let's just let a little more work happen and bring it back in January.
Well, it's the motion, it's the language of the motion that needs a little work, Senator Kiffmeyer. I think that my intention should be very clear here. Mr. Nobles has made it very clear that there is no legal direction. There is nothing in law that requires him to do the single audit. And I think the commission has been very unified in saying, we don't think that he should be doing the single audit any longer. And so in the absence of an agreement on specific language, I think that we should simply say that we're going to direct him to stop doing it, thereby telling MMB that MMB needs to pick it up. Now, how MMB does that, it's probably going to need legislation, and this can go through the regular process. But I think it is important, and I think Mr. Nobles has brought this up enough times, he needs direction, the staff needs direction. I don't know what the deadlines are, but the sense of this commission that we no longer want him to be doing the single audit, that this is not his responsibility any longer. And it's important for us to send that message. So I don't think there's a lot else that we have to decide here. It's simply a matter of how to phrase it so that we can have a proper motion.
Motion has been
Well,
made to the motion.
Thank you, Mr. Chair. I'm a little bit uncertain as to what the motion actually is because there was explanation and then language, but it seems as though the sense of this motion, as I understand it anyway, is direction from the Legislative Audit Commission to Mr. Nobles to discontinue doing the single audit.
Representative Liebling.
Yeah, Mr. Chair, I would say, okay, let me take a stab at the language again. So the motion would be that Mr. Nobles is instructed to cease doing the single audit and to instruct and to notify M&B of our instruction to that effect.
Mr. Nobles.
I think that will be sufficient. I think basically you're authorizing me to inform the commissioner of your the sense of the commission and your direction to the legislative auditor. Rather than having me do that unilaterally, I do that with your permission and with your authorization.
Senator Kiffmeyer.
Yes, that'll work.
Senator Cram, I see your head nodding.
It'll work for me.
I think Representative
Could you see it or hear it?
Really good suggestion and process for us. I'm sorry, I spoke out of turn, Mr. Chairman.
Any other discussion? Any other discussion on the Liebling motion? Clerk will take the roll.
Representative Hansen,
Aye.
Senator Curran,
Aye.
Senator Benson,
Aye.
Representative Bernardi,
Aye.
Representative Erickson,
Aye.
Senator Frentz,
Senator Frentz has a medical appointment. He'll be excused.
Senator Kiffmeyer,
Aye.
Senator Klein,
Aye.
Representative Liebling,
Aye.
Representative Pearson,
Aye.
Representative Quam,
Aye.
and Senator Rest.
Aye.
11 yes, 1 absent.
Ayes have it and ayes have it, not habit. And the Liebling motion is adopted. I see 2 blue hands still. Senator Kiffmeyer.
No, I forgot to take it down, Mr. Chair. Thank you.
Mr. Nobles, I believe that is all of the proposed legislation, but we do have the budget item. If you wanted to discuss the proposed budget, we have members gone over this, I think, in 2 meetings before. Mr. Nobles.
Mr. Chairman, and I know that time is fleeting here, and you have this document in front of you. You've had it for a period of time. I think what is needed at this stage is simply a vote on which option the commission supports. And we can certainly go over those options, but I think they're pretty clearly stated on the document that you have in front of you.
Okay, members, we've been through this. Representative Liebling.
Yeah, thank you, Mr. Chair. And I do want to make a motion that we approve option 4. But I also have a quick question for Mr. Nobles. When you put this together, were you taking into consideration that the audit work for the single audit would be off your plate?
Mr. Chairman, Representative Liebling, members of the commission, yes. Because we want to use the resources that we now put into doing the single audit for the federal government. We want to use those resources to do audits for the legislature and at the direction of the Legislative Audit Commission. So yes, that was part of the consideration with all of the options, but in addition to option 4, as you have proposed.
Mr. Nobles, if you could just state option number 4.
It would be to authorize enough funding that that OLA could add additional staff to handle special reviews. That would be 2 additional positions. And I might say those special reviews could cover a wide range of different possibilities, including IT work. So yes, it would simply give us two additional staff. I don't know if either of the deputies want to speak to the proposed number 4.
Mr. Nobles, right now, we only have Mr. Alter as the special review staff. Is that correct?
That's correct. He is often, though, has to be supplemented with pulling staff from other assignments. I often work on special reviews myself, legal counsel does, but having other staff dedicated to that purpose, I think would be very helpful.
So, Mr. Chair, if I could just speak to the motion briefly.
Yeah.
Thank you. So, members, we know that we're facing a very uncertain budget situation. We all know that. We don't know what it's going to be when we come in, and we're not passing this. We're not a committee that's appropriating funding. So, granted, there's a lot of uncertainty here, and we are proposing an increase with option 4, but I think members of the commission understanding how important these special reviews are and what an important function they are for the legislative auditor. I think it behooves us to make a recommendation like this, and it may not get all the way through the process, but I certainly think it would be, we would be well served to move this and just to be giving a signal to the legislature at large that we believe that this is a really important function. Thank you.
Any discussion on the labeling motion?
Mr. Chair, this is Representative Erickson.
Representative Erickson.
Thank you, Mr. Chair. Option 3, the status quo, does that not also give the auditors the flexibility that would be included in option 4?
Mr. Nobles.
Or M5?
Mr. Chairman, yes, I mean, I think we will always have discretion. I think the option 4 simply is an authorization for an amount of money with a direction of how it would be used. And we would certainly honor that if, again, as Representative Liebling points out, if this makes it through the process and there is some intent as to how we use this money, I think we always try to honor that. So I don't know if that fully answered your question, Representative Erickson.
Representative Erickson.
Thank you, Mr. Chair. That's adequate for now.
Senator Cran.
Thank you, Mr. Chair. The motion of option 4, my goal was to, at a minimum, that we would propose option 4 as well. One of the things I'd like to hear from Mr. Nobles is, in addition to the 2 special review, would that provide additional capacity that you could dedicate to the growing request of public data requests that you get? It seems to be a growing number, not only from the legislative body to try and obtain the basic information we need to function from state agencies, but it appears that our external organizations are also struggling to obtain that information, and it appears to be consuming a large portion of your time. So under option 4, with the review, you have 2 additional staff. Would some of those resources then be used for, or do we need to consider an additional position full-time and propose another FTE just for that portion of those requests for public disclosure?
Mr. Nobles.
Mr. Chairman, Representative or Senator Cran and members, you're absolutely right, and I won't take much time to belabor the point, but we are subject to the Government Data Act, and we get a lot of requests for data that we have in our work papers. We currently are working on our 16th, I think it is, request for the year. And the number doesn't really tell the full story, because these are very complex requests that have to be processed through multiple layers of control, including our legal counsel. So any additional resources help, and they are somewhat fungible. So we also are dedicating one of our existing positions already funded to try and help with data practice requests, which would really help our legal counsel, we only have one person who is legal counsel now. So we would like to and have authorization from the Legislative Coordinating Commission to fill a legal assistant for our general counsel, who is the primary person who has to process data requests. Let me just make one other point. The reason they're complicated is that in addition to having to honor requests, we have to ensure, and we just had a discussion about this, we have to ensure that we are not disclosing not public data inappropriately. There are people who can ask us for their own data, and they have a right under the Government Data Practices Act to see data that we have on them. And it takes a lot of time going through hundreds, sometimes literally many hundreds of pages to redact documents so that we are lawfully, accurately disclosing what we are required to disclose and protecting not public data that we cannot disclose. So thank you for raising the point, Senator Cran, but I think we're going to be well taken care of with that if we can just find another person to help in that area.
Senator Kiffmeyer.
Thank you, Mr. Chair. I do support the motion to adopt option 4. I think that in the light of what is happening, and we've seen that to be this year, whether it's data practices or other kinds of things, the requirements and the needs for the Office of the Legislative Auditor to be strong, be able to have the skills that they need, which is IT or maybe data practices. And so this is a key part of the legislative work. And I think option 4 positions the Legislative Auditor's Office to have that strength for the monumental amount of work that is going to be coming in this next year or two, especially, and the needs that we have. So I do support option 4.
Is there any other discussion?
Mr. Chair, Representative Erickson here.
Representative Erickson.
Thank you, Mr. Chair. Well, if this is something that we approve, this will be a recommendation, if I'm correct, coming then from the Office of the Legislative Auditor. But I think, we have to be prepared for hoping that we get the status quo, considering our financial condition going into this next biennium.
Members, I support the motion. I think it's important to ask. You don't always get what you want, but you get what you need. So you gotta ask first. So any other discussion? Any other discussion? Clerk will take the roll.
Representative Hansen,
Aye.
Senator Karan,
Aye.
Senator Benson,
Aye.
Representative Bernardi,
Aye.
Representative Erickson,
Aye.
Senator Frentz, Senator Kiffmeyer,
Aye.
Senator Klein,
Aye.
Representative Liebling,
Aye.
Representative Pearson,
Aye.
Representative Quam,
See,
Senator Rest.
Aye.
11 yes, 1 absent.
The motion is approved. Thank you, members. I believe we have no other business today. I want to thank all of you for your work during the last 2 years on this commission, and also Mr. Nobles and staff. If you could extend our thank you to all of the staff who work at the Audit Commission, and I want to wish everybody a happy holidays and a very happy new year. Members, any other comments, questions? We are adjourned.